Hi everyone, my name is Victoria Driesman and I'm going to be presenting on Case 8.5, Klein versus Pyridine Corporation, and Case 8.6, Palumbo versus Nikirk. Before beginning discussing the cases, I wanted to just go over a quick overview of what I'll be talking about. I'll be reviewing the facts, the issue, the rule, and the conclusion, and finally the answer of each of the following cases. So to begin, in the case of Klein versus Pyridine, there was a public display of fireworks put on by the Pyridine Corporation on July 4, 1967 at the Western Washington State Fairgrounds. It injured Danny and Marion Klein in an accidental explosion. What happened was an aerial shell went amiss and exploded near them. As a result, Mr. Klein suffered facial burns, eye injuries, and his clothes were lit on fire. Klein sued based on strict liability for participating in abnormally dangerous activities. The Pyridine Company did purchase a $1 million insurance policy as according to the requirements of Washington State. But according to the plaintiff, they failed on many other requirements of the state, including they failed to properly bury the motor tubes, they failed to give the local government a drawn image of the fireworks setup, and they failed to have proper crowd control monitors. The issue in this case is that the plaintiff and the defendant argued different reasons for why the arterial shell exploded. The evidence in the firework explosion was all destroyed, so it was impossible to prove the cause of the misfire. The plaintiff argued that it was because the Pyridine employees improperly set up the display, while the defendant argued that because one shell detonated, it caused another shell to be knocked over and therefore ignite and misfire. Although it was impossible to tell the real reason for the misfire, the court needed to address whether or not the Pyridine Corporation was strictly liable with a lack of evidence for the misfire. How the process began was that originally the Kleins filed on both product liability and strict liability. The Supreme Court granted strict liability to the plaintiff, but product liability as a summary judgment was denied. After this verdict, the Pyridine Corporation appealed the partial summary judgment to the Court of Appeals. This case, it was considered a first impressions case because the issue of strict liability against pyrotechnicians had never previously been brought to the Washington Supreme Court. In this appellate court, the primary question they were trying to answer was, did the Pyridine Corporation take on abnormally dangerous activities by putting on this public display of fireworks? And are pyrotechnicians strictly liable for the damages from public displays of fireworks? To answer these questions, we need to look at the applicable laws. The law the plaintiff was arguing was strict liability. Strict liability originates from Fletcher versus Rylands, where a mine shaft flooded on an adjoining property, and it was found that in that previous case, strict liability was held true because the placement of the mine shaft was inappropriately dangerous, and that is why strict liability was found true and eventually became part of the restatement of torts. In the restatement of torts, there were two sections allotted specifically to strict liability, Section 519 and Section 520. Section 519 is in regards to what strict liability is and how strict liability is based on abnormally dangerous activities. Section 520 of the restatement specifies what abnormally dangerous activities are. So we're going to continue and analyzing Section 520 of the restatement. The appellate court decided that 4 of the 6 sections of abnormally dangerous activities could be held true for Pyro Dene Corporation in this case. The 4 sections that they determined were viable in this case are: the first, the existence of a high degree of risk of some harm to the person, land, or chattels of others. Second, the likelihood that the harm that results from it will be great. Third, the inability to eliminate the risk by the exercise of reasonable care. And fourth, the extent to which the activity is not a matter of common usage. So in the case of the 4th section, the court determined that putting on a public display of fireworks is not a common activity. This is not to say that fireworks in general are not a common activity, but a large-scale public display is not. In the 3rd case, the inability to eliminate the risk, it was found that it's impossible for pyrotechnicians to completely eliminate the risk, and therefore Section 3 of abnormally dangerous activities was found true. The 2nd section, likelihood that the harm that results from it will be great, is clearly true. The harm felt by Mr. Klein in his injuries was great. And finally, the existence of a high degree of risk in putting on a public display of fireworks. There is a high degree of risk, especially in the case of an aerial misfire like that occurred in this case. The sections of abnormally dangerous activity that were found not true for this case were the fifth section, inappropriateness of the activity to the place where it was carried on. In this case, the fireworks were set off with a body of water between the location of the fireworks and the viewers watching, and therefore this body of water made this activity not inappropriately placed. And the 6th section being the extent to which its value to the community is outweighed by its dangerous attributes. The court determined that the value of fireworks to the community is outweighed by dangerous attributes, and this is why every year people set off fireworks on July 4th in celebration, because society more highly values the celebratory nature of fireworks over the dangerousness of the fireworks themselves. So because 4 of the 6 counts of abnormally dangerous activity were found true in this case, it was concluded that public firework displays are abnormally dangerous activity and therefore justify the imposition of strict liability. And so the court sided with the plaintiff. On to the second case that I'm going to discuss today, case 8.6 with Palumbo versus Nekirk. In this case, the plaintiff, a mail carrier, was attacked and bitten while delivering mail to the defendant. So let's look at the facts of this case. The plaintiff, Palumbo, was delivering mail to the defendant, and the plaintiff claims to have been viciously attacked by the defendant's dog when opening the mailbox. The plaintiff claimed that they were unable to see or hear the dog prior to the attack because there was a bush that obstructed the vision of the plaintiff. In the original claim of the plaintiff, they stated that they incurred personal injuries due to the viciousness of the dog and were looking to recover damages. So this brings us to talk about the issue and the rule in this case. The original verdict in the plaintiff suing based on personal injury was dismissed, and the defendant was originally favored. As a result, the plaintiff appealed, which brings us to the case today. The plaintiff appealed based on strict liability and tort that the dog owner should have known about the dog's vicious propensities. Vicious propensities are the tendency of an animal to be vicious. However, the defendant's prima facie, meaning what is accepted to be correct until otherwise proven incorrect, is that the dog had never shown any previous signs of aggression. According to the owner, the dog had never been aggressive to anyone before, had never bitten anyone before, and had definitely never exhibited any vicious propensities. Now we look at the answer that was found at the end of the case. The case ruled that due to the plaintiff's inability to provide evidence that the dog had any history of aggression, the theory of strict liability was rejected and the case was ruled not a triable issue. So why was this answer finalized? As I stated in past, the dog had never shown any previous signs of aggression, but in addition, the owner testified to the existence of a beware of dog sign to warn the mailman. They testified that the breed of dog was not known to be vicious, and then they also testified that the dog is almost always on a leash. Therefore, with the defendant's testimony of a lack of vicious propensities and the plaintiff's inability to prove that the dog had previously been vicious, the final ruling was in favor of the defendant. Thank you very much for listening, and I look forward to any questions you may have.